Good afternoon.
Good afternoon.
Ruben Guerra is a small community that is just up from Lake Kivu in Rwanda. Lake Kivu is a beautiful lake that is just below the continental divide between the Nile River and the Congo rivers. It's a very high altitude place. Ruben Guerra is home of a Presbyterian parish that's been in existence in that community for about 100 years. And is a place where there is a school, a hospital, various other development programs. On a Thursday morning, in about 4 years ago, I was in Ruben Guerra to witness a Gacaca trial. It wasn't actually a trial, but it was an early phase of the Gacaca process. There were maybe 200 people that had gathered, sitting around the side, some of them under umbrellas to shade themselves. And at the front of the crowd was a table with 19 people sitting at it. This was the Gacaca judge table. And at about 11:30, they began a community meeting. They got up, and the president of the Gacaca trials, who was a young woman in her 30s, who was well educated and worked as a school teacher, got up and read the instructions for what was supposed to be done that day. They were at the 6th of their meetings of Gacaca. It was actually more than 6, but there are steps that they had to go through, and they were at step number 6, which involved coming up with a list of those who were killed in their community and who they believed killed them. It was a time to make accusations of people that they believed might be guilty for the genocide that took place. The meeting went on as they went through a list of those that they'd already come up with who had been killed, and began to talk about who they thought might be responsible to bring charges against them. One man was mentioned, and an older woman, probably 65, fairly decrepit, got up. And she talked about this man, Omari, who had died near her house. She said that Omari lived across the street from her, and that the gang had come to kill him in his home. And so she went up the hill to try to talk to the leader of the local community, the responsible of the sector. She knocked on his door, and he told her, what can I do? It's a mob. I have no possibility of doing anything, old woman, so just go home. And she said, no, you can stop them. You can come, and you can speak. And she said that he just dismissed her and said, go back to your house, old lady. There's nothing we can do. So she went back home, she reported. She went back home, and a little later, the mob pulled the man out of his house and began to beat him and to chop him and eventually to kill him. And she said that she had witnessed the responsible coming down to actually watch this happen rather than stopping it from happening. As it so happened, a man in the back of the crowd stood up. He was a fairly large man, which indicates in Rwandan culture that he had a lot of money because it allowed him to eat. It turned out that that was the responsible of the community. And he got up and said, well, this is an older woman, and clearly she's a little addled. She doesn't quite know what she's talking about. The woman hopped up again and she said, no, I saw what I saw. And you can kill me if you want, but I have to speak the truth. And I saw, you were there. You watched this killing and you did nothing to stop it. Another woman, a younger woman who was sitting near her, stood up and she said, yes, I'm just a poor peasant woman too. But I saw this, I saw him there as well. Well, the judges said, wait, this isn't the trial yet. This isn't the trial yet. They intervened and said, but we'll take this name down and we'll put this on our list of the accused. There were other events that happened. This went on for about 2 or 3 hours. There were some things. But I mention this as a window into an amazing process that Rwanda has undertaken. That's called the Gacaca trials. Most of you are probably fairly familiar with the basic outline of what happened in Rwanda. When I first went to Rwanda in 1992, people hadn't heard of the country. People said, Rwanda, isn't that a woman's name? And then the genocide took place, and suddenly Rwanda exploded onto the world stage. And gradually, attention within the international community has grown. Americans have come to know about Rwanda. Finally, as Hollywood has gotten interested in Rwanda, it's emerged as one of the few African countries that Americans actually can name and know something about. On April 6, 1994, the president of Rwanda was killed in a plane crash, and this was used as an excuse to begin a long-planned campaign to wipe out enemies of the regime. The initial killings that took place were concentrated in the capital and included the various people that the regime thought were threats to their power. It was an authoritarian government that had been criticized by a democracy movement and had been threatened by a rebel movement that had been attacking the country. The genocide became an excuse for this regime, or a tool that this regime could use to try to reassert their power. And so they had lists of people to kill. The Presidential Guard and some other groups went out. They killed moderate people from their own ethnic group, the majority Hutu, and they also killed Tutsi, particularly prominent Tutsi initially. The Tutsi are the minority ethnic group, were about 15% of the population at the time. Over the next couple of weeks, violence began to expand into the rest of the country, and it became increasingly focused on the Tutsi minority ethnic group. It changed from something that had a lot of political overtones to being something that was clearly genocide, that clearly targeted a single group of people because of who they were. Within 3 months, somewhere between 500,000 and 1 million people were killed, the vast majority of them Tutsi. As Professor Pham has mentioned, 4 million people were displaced by this process. As the war broke out, as the genocide was going on, and a rebel army of mostly Tutsi who had been based in other countries, people who had been refugees, attacked the country and swept through and drove the former regime from power. You had 2 million people displaced within the country, another 2 million people driven out, as many as 1 million people killed. When, in July of 1994, after 3 months, the Rwandan Patriotic Front, the rebel army, took power, they were faced with a country that was devastated. You had massive numbers of people killed, massive numbers of people displaced. As a matter of fact, a majority of the population was driven from their homes. The physical infrastructure was destroyed by war. And the social fabric of the country was torn even more deeply. The RPF was faced with a daunting task in rebuilding the country and asserting its authority. One of the major focuses that the RPF decided to take on to rebuild the country, as a matter of fact, the primary focus that they embraced in terms of promoting reconciliation was to use trials to hold people accountable for what had happened, and to build rule of law and promote reconciliation. The international community was very supportive of this and also took justice as one of their primary focuses for involvement. The international community set up the International Criminal Tribunal for Rwanda and began to prosecute a few of the major offenders, people who had organized the genocide, people who were in important positions of power at the time of the genocide. The Rwandan government itself began to arrest thousands and thousands of people under accusations of genocide participation. Within a year, somewhere around 60,000 people were arrested. Within 3 years, 130,000 people were arrested. The prison system in Rwanda at the time was capable of accommodating 7,000 people, which means that you stuffed 130,000 people in prisons that required people to sleep in shifts, to sleep on the roofs of buildings, to sleep in the showers and in the bathrooms, because there were so many people who had been involved in the genocide or were accused of involvement. This posed a terrible political problem for the RPF. The RPF, the Rwandan Patriotic Front, came to power having stopped the genocide. And because of that, they had a certain moral standing in the international community. But imprisoning thousands and thousands of people without trial for many years in deplorable conditions, where there were problems with cholera initially, and then there were problems with a variety of other diseases that were passed, with problems with nutrition and water, was posing a real dilemma for them in terms of how the international community would regard them, as well as some accusations of other human rights abuses that were carried out by the RPF. And so they began to hold trials, but at the pace that trials could be taken care of, because of the number of people who were judges, the number of people who were lawyers, and others who were involved in the judicial system, it was estimated that it would take 100 years to try all of the people who were in prison. The Rwandan government realized they needed to do something. And so initially, in response to the problem of too many people in prison, they decided that they would try a mass, innovative new effort of grassroots justice. It came out of some meetings in 1998 and 1999 that were held, that brought together people from various positions of power throughout the country. And they determined that what they could do was to reach back into the Rwandan past and take a traditional mechanism of conflict resolution and adapt it to the present needs of the country. The Gacaca was something that had been a tradition within Rwanda. Gacaca literally means small grass, because what happened in communities in Rwanda was that when there was a conflict, when there was a fight between members of a family, or there was a conflict over someone having stolen something, rather than going through traditional court systems, what they did is they would bring together the elders of the community, who would sit on a lawn, a small grass, and hear the various sides of the story, and then render some kind of judgment. So if someone stole a cow, they would sit and they would listen to the family that felt that the cow had been stolen from them. They would listen to the people that were accused of stealing the cow, and then they would render a judgment over what would happen. If they accepted the story, they might require the family to reimburse the other family for a cow. Sometimes they even dealt with serious cases of murder and other things, although usually it was just small property crimes or a conflict between a mother-in-law and her daughter-in-law. It involved the elders making decisions and helping to bring peace back to their villages. Well, the proposal that the Rwandan government embraced was one that would take that tradition of a grassroots justice that involved just local respected individuals in the community and adapt it for the modern age. They established a Gacaca law that combined this tradition of grassroots justice with modern legal standards. And they established something that would have local, elected, respected individuals form courts in their local communities and render judgment on genocide crimes. These would be people who were not professional judges. As a matter of fact, if you were a professional judge, you could not become a Gacaca court judge. But these Gacaca courts would involve non-professional people who would receive minimal training, who would have open-air sessions that would involve the whole community, where people could talk about what happened, where they could hold trials, and then render judgment for people in their community. Within Gacaca, to try to make it work, there were a couple of things that were planned. One is that people were encouraged to confess their crimes. If people confessed before the Gacaca courts and talked about what they had done, and implicated others in the crimes, told about who they saw committing crimes, then they would have a reduced sentence, most of which would involve community service within their community. So it was an opportunity to get people out of prison and get them back into their communities to work, to provide for their families. The Gacaca trials were conceived of having two phases. The first phase was an information phase, in which the whole community would get together, and they would come up with a list of all the people who were killed, all the property that was stolen, all the goods that were damaged, and then come up with a list of people that they accused of participating in this. Those who were accused of the most serious crimes, those who were accused of engaging in rape, those who were accused of having organized the genocide, or people who were particularly enthusiastic about their killing, would still be tried in conventional courts. But all the rest of the people who followed orders, who maybe didn't kill but only looted or engaged in the genocide in some other ways, would be sent to their local communities to be tried. The second phase of Gacaca involved those actual trials. The smallest courts at the local level would deal only with property crimes. The next courts up would deal with crimes of bodily harm, and the courts at the district level, that is the county level, would deal with cases of people who actually killed in some way, but weren't the most serious killers. Elections were held in Rwanda in October of 2001 to elect judges in 9,100 cells, 1,554 sectors, and 106 districts or counties. What that means is in total, because in each cell 19 people were elected as judges, over 100,000 people became Gacaca judges in Rwanda. Now there were a few innovations in this over the former Gacaca. One is that women could be Gacaca judges, and young people could be Gacaca judges as well. The only requirement was that these had to be respected individuals. As a matter of fact, the name for these judges is Inyangamugayo, which means literally those who detest corruption. basically, the upright people. The Inyangamugayo could be women, they could be youths, and they were elected by their communities. They were given a minimal training session, and then because of concerns over how this all would work, the government gradually phased in the Gacaca trials. In June 2002, they started the trial phase where in one sector in each of the country's 11 provinces, they would have a Gacaca trial. About 6 months later, they expanded it to one sector in each county. And then finally in January of 2005, they started the Gacaca process in every single community in the country. Now, if you think about this, this is an extraordinarily large undertaking. It's innovative, it was something new, and it involved virtually everyone in the country. Initially, participation in Gacaca was voluntary, but because there were some problems getting people to participate in the trial phase, they changed the law and required people to participate in Gacaca. What that means is one day out of the week, every person in Rwanda was supposed to go and attend these community meetings in order to sit in judgment of members of their own community. It's an extraordinary undertaking in response to something extraordinary that happened in this country. And what I want to talk about fairly briefly tonight is what went right with Gacaca and what went wrong. I want to talk about Gacaca and its possibility of being a model, and also the dangers that we have to look at from this Gacaca case. When I first heard about Gacaca, I was quite skeptical. Having lived in Rwanda before the genocide, I knew that the community bonds had been fairly strong, and yet that didn't prevent genocide. Having come back after the genocide to be the head of the Human Rights Watch office for a year, I also saw that Rwanda was still a very authoritarian country where there was a lot of suspicion, and I was very skeptical about what could happen with this mechanism. But when I was at the University of California, Berkeley for a couple of years and directing research projects in Rwanda, I was able to spend a lot of time in Rwanda. I taught a course at the University of Rwanda in Butare. I engaged in a variety of research projects, including a survey that Professor Pham and I directed. And I actually became very sympathetic to the idea of Gacaca. The more that I looked at it, the more that I thought it was an innovative and creative response to the situation. Rwanda was in many ways in a no-win situation in terms of human rights. On the one hand, Gacaca had some problems from a human rights perspective because it didn't involve defense attorneys, because it didn't involve professional judicial personnel, because you had people who were not trained in the law rendering judgment on the law, capable of sentencing other people. There are a variety of human rights concerns that were raised, and initially Amnesty International was quite critical of Gacaca as a proposal, as was Human Rights Watch, and other groups were very skeptical of this because they felt that it didn't meet the standards of fair trials that the Western courts had established. What I saw as I looked at Gacaca, though, was that it provided some interesting opportunities to correct for some of the problems in traditional trials. For one thing, one of the challenges that Rwanda had in terms of its human rights record was keeping people in prison without trial for 10 years or longer. There were people who were in prison under false accusations with no chance to defend themselves for more than a decade. That itself is a major human rights offense. And establishing Gacaca allowed the timetable for trials to move up. It got cases moving and provided people a chance to defend themselves and get them out of prison. So there was one advantage right away in terms of speeding up trials. But there are also ways in which this was a very innovative method. Frankly, in the research that we conducted in Rwanda, we found that most Rwandans were very skeptical of both the ICTR and Rwandan courts. Because these were courts that reflected more Western styles of doing justice. They were distant from the people. The ICTR was held in another country, in Tanzania, and even the Rwandan courts were held in places that were not accessible to the population. So most of the public never attended courts. They were conducted often in French or in English, in languages that the people themselves didn't understand, and there had to be translation. The classical model of justice was something that in a lot of ways didn't resonate with the population. Furthermore, there was a sense in a lot of people's parts that classical justice was corrupted. That the judges themselves almost all came from one ethnic group. That was the ethnic group that was now in power, the Tutsi, the minority ethnic group. Most of them were people who had not been in Rwanda at the time of the genocide. And so there was some skepticism on the part of the people whether these judges could be unbiased. And furthermore, there was also a sense that a lot of the judges were frankly being bought off. That the wealthy people were able to pay the judges off and get away with their crimes, whereas poor people weren't. And so it seemed like the peasants were the ones who were being tried, whereas the wealthy were able to get away, even though usually it was the wealthy who planned the genocide. What Gacaca offered was a different model, where trials were accessible to the population, where they were held in the community, where everyone could see what was happening. You had 19 judges, which a lot of people said, it's pretty hard to bribe 19 people. We're not that rich in our poor farming community. Plus, because it's in the community, if bribery is going on, if there's cheating that's going on, we'll be able to see it. In the survey that we conducted before Gacaca had taken place, we conducted it right in this crux after the judges had been elected, but before the trials had actually begun. And we found that Gacaca was massively popular. People were skeptical of the ICTR, skeptical of national courts, but they thought Gacaca would be great. The question is why? And there were other surveys that were conducted at the same time that found similar results. Well, it's because people thought that those trials would be accessible and transparent. People believed the Gacaca trials were things that they would control themselves. And they had faith in their own communities. At their best, Gacaca trials, in fact, did provide amazing opportunities for communities to come together and talk about what happened and to work through what went wrong in the genocide. Even though Gacaca was initially designed just to try to respond to the fact that you had too many people in prison, as it was designed, experts were brought in from other countries, and there were attempts to bring in ideas like the Truth and Reconciliation Commission in South Africa. There was an idea that Gacaca trials could serve a purpose of restorative justice, not just of punishing people, but of allowing communities to develop a transcript of what happened, to establish the truth about what went wrong, and to provide an opportunity for victims to confront those who victimized them, and for communities to come together and discuss the ruptures that had taken place. The story that I told you of one of the Gacaca trials, Gacaca cases that I witnessed, is indicative of communities where Gacaca really did bring out some conflicts and got people talking. It got people to speak about what happened. It allowed peasants who had been oppressed by those in office to talk about the crimes that they committed. And where it worked well, it in fact provided these wonderful opportunities. Unfortunately, what I want to suggest is that there are a number of problems that happened within Gacaca as well. A lot of people looking at Gacaca were very impressed by it and believed that it could be a model that could be used in other countries. Rather than having large international justice, rather than having the International Criminal Court, rather than having big, impressive national trials, there were a lot of people who looked at Gacaca and said, well, this is a model. Let's take justice to the people. And let's use this as something that could happen in other countries, because almost all countries have some tradition of dispute resolution that isn't courts, that happens outside of the courts. And I think that there's some validity to that. In principle, there were things about Gacaca that were very good. Where it worked well. But in many places, it didn't work that well. The question is why? There are several things that I want to mention. First of all, Gacaca was limited in what it was allowed to focus on. The Rwandan Patriotic Front was interested in dealing with the genocide, having accountability for the genocide, and getting people out of prison back into the communities so that they could reestablish order and rebuild their societies. What the Rwandan Patriotic Front was not interested in was in being held accountable for the abuses that it had carried out. Because in the process of taking over the country, in fact, the Rwandan Patriotic Front also engaged in some human rights abuses. They didn't conduct genocide, but they did carry out summary executions of people. They carried out massacres in some communities. And then in 1996, when they invaded Congo, they bombed refugee camps and chased refugees into the forest and slaughtered them in the thousands. What the Rwandan Patriotic Front did not want was accountability for its own actions. And so one of the first things that they did was to say that Gacaca is not a full accounting of all the crimes that have been committed in our community, but is instead only an accounting of actions that were taken in the genocide. When people came to Gacaca hearings early on, they tried to raise the issues of all the people in their community who had been killed. And in some cases, those people were in fact killed by the Rwandan Patriotic Front. They were told that those cases are not acceptable. Those names are not included on the list of the dead, and that those would not be considered within Gacaca. One of the communities where we conducted our survey and where I also carried out qualitative research was in an area that fell very quickly under RPF control. And in that area, there was almost no genocide, but there were thousands who were killed in reprisal attacks and other attacks by the Rwandan Patriotic Front. In that community, when Gacaca started, a lot of people showed up. And yet they found out that the dead in their families were not to be considered and could not be discussed in public. So people stopped attending Gacaca because they felt it wasn't, in fact, about them. It wasn't going to solve any of their problems, and it was not going to bring any accountability or justice. As a matter of fact, so few people attended Gacaca that many weeks the meetings simply couldn't be held because no quorum was reached. Unfortunately, in the case of Gacaca, the government was interested in promoting reconciliation at one level, but it was also interested in promoting its own political causes at the same time. And so Gacaca in many ways became politicized. The government not only said that you couldn't deal with RPF crimes, but intervened in ways to say that they wanted to make sure that enough people were tried. They intervened often in the meetings to say that no, they aren't being done correctly. You can't talk about this, you have to talk about this. When people tried to confess for their crimes, if they didn't list enough names of other people who were involved, their confession wasn't accepted. And they couldn't list just any names. At some of the Gacacas I were at, people would list names and they'd say, well, these people are all dead already. Now you can understand why if you're going to accuse people, you might accuse those who are dead. They're not generally so good at coming back and wreaking vengeance on you. So people would list the dead, or they would list those who had already confessed. And often the judges would say, no, that's not enough. You have to give us new names, or we won't hold you, we won't allow you to reduce your sentence. In other words, what the government wanted to do was to accuse a lot of people. They wanted to hold them accountable, but to keep the focus only on the genocide. The problem that I'm talking about there is the politicization of justice. It's the attempt by the government to manipulate the judicial system for its own political purposes. There are some other problems with Gacaca which are more inherent to its nature, which are somewhat more troubling. One of those is that there is a flip side to the accessibility of Gacaca, and that is that because it's happening in your local community, because it involves people in the community accusing one another, it means that those living in the community who are accusing others become vulnerable to reprisals. One of the problems that emerged was that genocide survivors who were willing to testify in Gacaca exposed themselves to the vengeance of those that they accused, or their families. There were a number of cases of genocide survivors who, when people, either because they testified in Gacaca or there was fears that they would testify, they were assassinated. We know of dozens of cases like this, where people who were going to testify in Gacaca were murdered within their own communities. When you have something that is this massive, and it's so present in the countryside, and yet doesn't really have much funding, it's a completely voluntary effort on the part of the population, it means that you're exposing people to risk. And it depends upon the goodwill of the community. And unfortunately, because that community is being accused, that goodwill was not always present. A second major problem is that Gacaca, in order to work, required the participation of the community. And there were places where that happened. In Ruben Guerra, where he talked about, for example, people were engaged in Gacaca. They discussed, they attended, and positive things came out of it. But in many communities, there was a complicity of silence. There was a complicity among those who had participated in the genocide with others in the community to not tell the truth, to not speak up. Even though there might have been some incentive for people to confess, most people who did confess confessed to very minor crimes. People confessed to property crimes, or they confessed to having been present when someone was killed. Very, very few people confessed to actually having killed, or certainly having killed multiple times. When people confessed, they confessed to minor things. And others in the community were often members of their families. It's typical in a rural community in Africa that those who live there are often related, either through blood or marriage. And so if you're holding a trial among people who are from a couple of extended families, who's going to stand up and condemn their brother? Who's going to stand up and condemn their cousin, or their father, or their son? Well, often they're not willing to do that. And so in those cases, when it's community organized, people will attend and say nothing. One of the major problems that Gacaca confronted was a failure on the part of all the population to be willing to participate. Now, that wasn't true everywhere. There were a few things that encouraged participation. One of the things, interestingly, that has encouraged participation is that there was a born-again Christian movement that swept through the prisons of Rwanda, that encouraged people to confess their sins. And so in communities where where there were a lot of these born-again people, they actually were willing to speak up, and in many cases to admit what they had done wrong, or to condemn others. But that wasn't true everywhere. And even in some of those cases, people were inclined to confess to smaller things, because after all, we're human and we don't necessarily want to go back to prison for a long period of time. I'm going to wrap up now so that we can have time for questions and discussion. I don't want to take a lot of time talking, but I just want to draw a couple of lessons from this case of Gacaca as we think about transitional justice and these types of things. Could Gacaca be replicated elsewhere? Are there other countries that could have this sort of thing, and should they? One of the things as I look at Gacaca that I realize is problematic is when we talk about transitional justice, when we talk about things like the International Criminal Court and the International Criminal Tribunal for Rwanda or for former Yugoslavia, when we talk about, this has been happening in a lot of different places, whether it's putting Pinochet on trial in Chile, or it's the Truth and Reconciliation Commission in South Africa. A lot of countries coming out of conflict are now talking about the need to hold some form of accountability, hold some sort of public means of dealing with the past, which we call transitional justice. The problem that I find with transitional justice after looking at the Rwandan case is that it assumes a transition. It assumes a transition from an authoritarian government to a democratic government. It assumes a transition from violence to peace. It is, in other words, teleological, which means it looks at history as though it moves in a linear fashion towards a goal. The reality in Rwanda is that there was a transition, but it was a transition from one type of authoritarian regime to another type of authoritarian regime. It was a transition from one regime that carried out violence in a particular form, genocide, to another regime that carried out violence in another form, through political repression. Now, the regime that followed may have been better in some ways, but it was not particularly democratic. It was not particularly interested in true justice. It was not particularly interested in real accountability. And so to think about transitional justice in this case is problematic, because it was neither a real transition nor real justice. Unfortunately, one of the things that the Gacaca trials did was to, rather than individuating guilt, which is one of the things that we argue these trials can do, rather than finding individuals who are guilty, which then implies that other people are not guilty and allows them to go on with their lives, the government used Gacaca to try to imply that all Hutu were guilty of participation in the genocide. As Gacaca got going, government officials began to talk about there being 1 million people put on trial for participation in the genocide. Maybe more than 1 million, maybe 2 million, some government officials said. Now if you think about it, Rwanda was a country of 7.7 million people. 1 million or so were killed, so that takes us down to, let's say, 7 million. All right? Half of those were under 15, and therefore can't really be held accountable. All right? So that takes you down to, what, 3.5 million. Half of those were women, and therefore didn't really participate in the genocide. The implication then, if they talk about 1 million people participating in the genocide, is that 2/3 of Hutu men participated in the genocide. Now, I've conducted a lot of research on the genocide, and I can tell you that that is an exaggerated figure. That does not come anywhere close to the reality. And yet, for the government's purposes, what it did is it said, Hutu, in general, are guilty. Therefore, they shouldn't be in government. They shouldn't have positions of power. And we, who came in and stopped the genocide, should continue to rule. The irony is that the government doesn't allow people to talk about ethnicity. Right now, it's taboo to talk about ethnicity, and if you do talk about ethnicity, you can be thrown in prison accused of fomenting a genocidal ideology. And yet, in the way that these trials were carried out, crimes by Hutu against Tutsi were part of the Gacaca trials, but any crimes committed by Tutsi against Hutu would be excluded. The only way of judging exclusion was based on ethnicity. It wasn't articulated in those terms, but everyone in Rwanda knows that subtext and knows that that's what it meant. And so, in an ironic case, justice is used in this case not to help to find those guilty, but to imply that all people in an ethnic group are guilty. And that, frankly, is not very just. I'll stop there and open up for questions. Thank you.